SJC-12519, Commonwealth v. Robert Beauchamp.
Mr.
Am I in the right seat, Fran?
Mr. Beauchamp, good morning. We can see you clearly. Hopefully, we can hear you loud and clear. So speak loudly and slowly, and you have 10 minutes, sir.
Okay, thank you. Chief Justice and Associate Justices, this is an appeal to the full bench of the single justice's March 29, 2018 denial of my GL Chapter 211, Section 3 petition to vacate the appeals court's decision in Commonwealth versus Beauchamp, 49 Mass Ave Court 591, 2000, primarily on the ground of lack of jurisdiction. The Commonwealth filed no opposition to my petition, and the single justice denied it without a hearing and without any explanation whatsoever. The primary constitutional issue presently before the full bench is as simple a constitutional issue as it could possibly be. To wit, the Commonwealth claims that the July 1st, 1979 amended version of GL Chapter 278, Section 33E is controlling in my case. I claim that the pre-July 1st, 1979 version of 33E is controlling in my case. If the Commonwealth is correct, then the appeals court did have jurisdiction to decide my direct appeal in 2000. On the other hand, if I am correct, then the appeals court lacked jurisdiction to decide my direct appeal in 2000. In its brief at page 7, the Commonwealth concluded by asserting, quote, there's no basis in the law for review of defendant's 1998 conviction where this trial post-dated the statutory amendment of Section 33E, and the defendant was never in jeopardy of conviction for first-degree murder. And therefore, the single justice properly denied his petition, unquote. Excuse me. The Commonwealth conveniently ignores the dispositive, inconvenient fact that the SJC has already unanimously decided 3 times in Davis, Festa, and Beauchamp that, quote, the amendment to GL Chapter 278, Section 33E is effective only to offenses committed after July 1st, 1979, unquote. My offense indictment for first-degree murder occurred in 1971, 8 years before the amended 33E even became effective, and I might add 1 year before the appeals court even came into existence. Nevertheless, notwithstanding Davis, Festa, and Beauchamp, the Commonwealth in 2019 persists in arguing to the full bench that the 1979 amended version of GL of 33E is controlling in my case. However, 20 years ago, the Commonwealth was then highly concerned, and rightfully so, about the exact same lack of jurisdiction, ex post facto, and due process issues that are being orally argued to the SJC this very day. As a result of these very real, foreseeable concerns, the Commonwealth made repeated efforts during 1998 and 1999 to get my direct appeal transferred from the appeals court to the SJC for lack of jurisdiction. For example, on June 8, 1999, retrial ADA now Judge David Kunis asserted to Judge Thomas Connolly that, quote, essentially what happened was the 33E review that's available to first-degree murder convictions by the SJC. Prior to 1979, the statute had changed in 1979. Prior to that, indictments returned before 1979, the defendant was entitled to a 33E review on a second-degree murder conviction. So where this indictment was found in 1971, we believe that the SJC has jurisdiction over the case. The Middlesex DA's office talking. They apparently don't want it, and they said file it with the appeals court, unquote. The Commonwealth's other argument in its brief at page 7 asserts that because I was no longer in jeopardy of being convicted of first-degree murder at my 1998 retrial, I was no longer entitled to a 33E review because the 1979 amended version of 33E excluded defendants who were indicted for first-degree murder but convicted of second-degree murder. Excuse me. Of course, the Commonwealth's jeopardy argument totally collapses because at my 1998 retrial, I was still in jeopardy being convicted of second-degree murder, whereas the pre-July 1st, 1979 version of 33E entitled me to the special review by the SJC whether I was convicted of first or second-degree murder. Now, the following is the most dispositive ex post facto argument I will advance to the full bench. Simply put, if the SJC had reversed my 1973 second-degree murder conviction, say in 1974, and I was reconvicted of second-degree murder, say in 1975, I would have undoubtedly received a 33E review of the 1975 reconviction, because it was not until 1979 that the appeals court was even granted jurisdiction by the legislature to review any second-degree murder conviction derived from a first-degree murder indictment. The fact that my reconviction post-dated July 1st, 1979 is totally irrelevant because my right to a 33E review is grounded in the version of 33E that existed in 1971, the year of the offense and indictment for first-degree murder. Indisputably, the most dispositive statistical fact proving that the appeals court lacked jurisdiction to decide the direct appeal of my 1998 reconviction for second-degree murder is as follows. Since 1979, the appeals court has decided hundreds of direct appeals of defendants indicted for first-degree murder but convicted of second-degree murder. However, of all these hundreds of direct appeals to the appeals court, my direct appeal is the only direct appeal where the offense and indictment for first-degree murder occurred before July 1st, 1979, the only one. In 1899, in Murphy versus the Commonwealth, the SJC ruled that, quote, the law is subject to ex post facto objections if it will operate to deprive a party of substantial rights and privileges to which he was entitled as to the law stood when the offense was committed, unquote. In 1971, when my offense was committed and I was indicted for first-degree murder, as to the law stood, I was entitled to the substantial right of a 33E review by the SJC, whether I was convicted of second-degree murder, or first-degree murder, or second-degree murder, based upon an indictment for first-degree murder. Since the SJC's decision in Murphy, neither the federal nor state constitution has been amended to abolish their respective ex post facto laws prohibitions, so Murphy continues to be black-letter law. In Commonwealth versus Davis, the SJC ended its decision by stating, quote, whatever conclusion might be reached on strict analysis, we think that this is a field where the court does well to tread lightly, and so we are inclined under the influence, if not the command, of the ex post facto prohibitions to rule that special review remains available, whereas in the present case, the offense resulting in a second-degree murder conviction upon an indictment in the first degree was committed before July 1st, 1979. As to such cases, we shall follow our practice of sua sponte transfer to this court from the appeals court, unquote. Wherefore I respectfully report that the full bench tread lightly and vacate the appeals court's decision in Commonwealth versus Beauchamp for lack of jurisdiction, as the Commonwealth itself argued to the SJC 20 years ago, when it then served the Commonwealth's interest to get my direct appeal transferred from the appeals court to the SJC. I would add that the great irony in this case is if I had won in the appeals court, the Commonwealth would be making the exact same arguments to the SJC that I just made. I thank the full bench for its time and consideration of this appeal.
Thank you, sir.
Thank you.
Mr. Charles?
Thank you. Good morning. May it please the court. Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth.
If you would speak up a little bit to make sure that Mr. Beauchamp can hear you, please.
Absolutely, Your Honor. Mr. Chief Justice. First, I just want to note for the court that the defendant's appeal of his most recent motion for new trial is currently pending in the appeals court, and we had oral argument on that in December. That was the impetus for the 211-3 originally that is before this court. I will just briefly note, as I mentioned in the Commonwealth's brief, that this issue has largely been resolved already. This court, on the docket of the defendant's direct appeal of his 1998 conviction, there is a clear entry that this court declined to take jurisdiction of the case. I should have noted this in my brief, but will also point out now that on the defendant's application for further appellate review of his direct appeal, FAR 11519, on November 30th of 2000, a entry entered on that docket denying his motion for consideration, quote, because the defendant having been retried on only so much of the indictment as charged murder in the second degree, his case was no longer a capital case within the meaning of General Laws, Chapter 278, Section 33E, either before or after the statute's amendment.
Mr. Charles, the only argument I can imagine here is that even though the second trial after the reversal is only for second degree, and so therefore it seems like the predecessor to 33E doesn't apply. I guess the only argument I can think of is that the original indictment was for murder in the first degree, and the language is a case in which a defendant was tried an indictment for murder in the first degree and was convicted of either murder in the first degree or second degree. So it might be a tortured reading of the statute, but the argument would be, well, it's still the indictment that was returned by the grand jury for murder in the first degree.
So that's an interesting point, Your Honor. I would note that in Middlesex, in this case and in all other cases, our indictments for murder are not specific to degree. The defendant is generally indicted for murder, and then the Commonwealth proceeds to trial under whatever theories of murder it deems appropriate. And I think that's reflected. If you look at Volume 2 at page 5 of the defendant's 1998 transcript, when the indictment is read, it's not the defendant deliberately premeditated the murder and with intent to kill, shot the victim, Charles McGrath. It is a general reading of a murder indictment, and then the defendant proceeds to trial and is subject to jeopardy only for second-degree murder. So I would dispute the characterization as a first-degree murder indictment. I don't know that this was an intentional act by the Commonwealth back in 1971 to subvert anything. Obviously, the appeals court didn't exist back then, but we have always proceeded generally on a murder indictment, not a first-degree murder indictment or a second-degree. So I would argue that here, where clearly there was no risk of jeopardy for first-degree murder, and where a capital case as defined by Davis is essentially a case where the defendant is subject to the possibility of life without parole. Here, the defendant wasn't at his retrial. The defendant was merely tried for second and convicted of second-degree murder. And I think by virtue of the fact that this court declined jurisdiction in 1999, that this court made an explicit notation when the defendant applied for further appellate review, and that the defendant has had several additional appeals of post-conviction collateral motions for new trial that have gone to the appeals court, it's fairly clear that this court, the appeals court, and all the parties involved believe that that is the appropriate venue that has jurisdiction over his case. Unless there are additional questions, I'm prepared to address the second issue that the defendant raised, but if the court has no questions, I'll rest.
Do you agree that if the Commonwealth, when it was retried in 1998, had not said at the beginning of the trial, we seek only a conviction of murder in the second degree, that he'd be right?
I 100% agree with that assessment.
So it's purely because of the limitation which the Commonwealth imposed upon itself at the beginning of the trial, which foreclosed the possibility of a first-degree murder conviction, that you argue he's wrong?
That is correct. Because the defendant was never subject to the life without parole punishment that is attendant to a trial for first-degree murder and conviction of first-degree murder, he does not fall within the purview of the predecessor statute to the present 33 as discussed in Davis.
And what was the jury's verdict in the first trial?
The first trial, the verdict was second-degree murder.
So he couldn't have been tried for first degree.
Well, I would say that that is not really for purposes of the interpretation of the statute, that is not really a dispositive fact. The indictment, again, not to regurgitate the same point, but was a general murder indictment. The defendant only faced prosecution for second-degree murder.
Because that's all he could.
That may be true, but that doesn't. I don't think that should alter the analysis of where his appeal should go, where he was tried. Subsequent.
I don't either. I don't either. I'm just making the point that
that is accurate, Your Honor. And again,
there was never any jeopardy for first degree because of double jeopardy. He was only found guilty of murder in the second degree.
Correct. And again, had there been a possibility and had we sought to proceed on a first-degree murder indictment, I would not quibble with this court as to the appropriateness of this court retaining jurisdiction over the appeal. But given the way things played out and the fact that the defendant was only in jeopardy of a second-degree murder conviction in 1998, his appeal was properly handled by the appeals court. This court correctly denied further appellate review, identifying the salient issue, and Justice Cipher correctly denied his petition for extraordinary relief under 211.3, and I'd ask that you affirm that ruling.
Okay, thank you.
Thank you, Your Honors.